No, no, no. Don't panic. Don't cancel your adjustment of status case. Don't assume the law has changed, because it hasn't. Let me say that again. The law has not changed. USCIS memo sparks panic, but the law remains exactly the same. And the clearest indication appears in the very first line of the USCIS memorandum. The memorandum begins with these words: "This memorandum reminds," not "this memorandum changes the statute," not "Congress amended the law," not "adjustment of status has been eliminated," not "Section 245 has been repealed." It says this memorandum reminds, and that distinction is legally significant. A USCIS memorandum is agency guidance. It may explain how the agency interprets existing law or it intends to exercise its authority, but it is not itself an act of Congress. That matters because USCIS does not have the power to amend the Immigration and Nationality Act through a memorandum. Only Congress can enact, repeal, or modify federal immigration statutes. With that framework in mind, let's talk about what adjustment of status actually is. Adjustment of status is not some loophole. It is not an exception. It is not a favor. It is not an act of charity by the government. Adjustment of status is a statutory immigration benefit created by Congress for more than 70 years. Since 1952, millions of immigrants have adjusted status inside the United States. Spouses of US citizens, parents, doctors, scientists, engineers, military families, workers, dreamers of a better life. Entire generations of Americans exist today because Congress created adjustment of status. Now, some people are reading headlines and saying USCIS says adjustment of status should be approved in extraordinary circumstances. And that sounds terrifying until you stop and ask one simple question. If adjustment of status was intended to be available only in extraordinary circumstances, then why did Congress create an entire section of the Immigration and Nationality Act devoted to it? Why has USCIS approved hundreds of thousands of adjustment applications year after year? Why has the agency itself spent decades encouraging eligible immigrants to file Form I-485? The answer is straightforward: because adjustment of status is a statutory benefit established by Congress. And Congress has never repealed it. Congress has never abolished it. Congress has never restricted it solely to extraordinary circumstances. That's why every immigration officer takes an oath to follow the law, not headlines, not political pressure, the law. And what does the law say? The law provides that eligible applicants may be adjusted to permanent residence. That means Congress granted USCIS a measure of discretion in adjudicating individual cases. But agency discretion is not the same thing as legislative authority. Discretion operates within the boundaries set by Congress. It is not unlimited. It is not arbitrary. It is not personal preference. The Supreme Court has repeatedly recognized that immigration agencies may not exercise discretion in an irrational or arbitrary manner. The Board of Immigration Appeals has likewise explained that officers must evaluate and balance favorable and unfavorable factors in individual cases, individual people, individual facts, not blanket assumptions, not predetermined outcomes, not deny first and ask questions later. America is a nation of laws, and administrative agencies must operate within the limits of those laws. So here's my message to immigrants watching this video. Take a deep breath, read beyond the headlines, understand what this memorandum actually says. Most importantly, understand that it does not repeal adjustment of status. It does not erase Section 245. It does not eliminate family-based green cards. It does not eliminate employment-based green cards. It does not cancel pending I-485 applications. And it certainly does not give USCIS the authority to rewrite a statute enacted by Congress. The law remains the law. Congress wrote it, Congress controls it. And until Congress changes it, adjustment of status remains one of the most important immigration benefits in American law. So don't panic, don't spread misinformation, don't let fear make decisions for you. Know the law, understand your rights, and remember, a memorandum can provide guidance. A memorandum can interpret existing law. A memorandum can explain how an agency intends to exercise its discretion. But a memorandum cannot amend, repeal, or rewrite an act of Congress. And that's the part nobody is telling you. Share this video with every immigrant family you know, because facts are stronger than fear.